That's it. There I can see it. Very good. Ladies and gents, thank you very much for your time. My name is Christiaan Grosskopf. I've actually been working for quite a few years in Laos and in Thailand. So I know and I really enjoy that part of the world. I actually have got a house in Thailand, and this is my base. Mr. Trong, thank you very much for this opportunity. And just a little bit of me is I've been working in construction as a civil engineer for about 35 years now. Most of that time was either on site or in the execution of works. So I've had a very good chance to get quite a lot of experience with situations on site. Mr. Trong, next screen, please. So what is interesting, there's a company, Arcadis International Consulting Engineers. They do frequent reviews of the amount of disputes in construction. And as you can see from those graphs, the amount of disputes in construction is actually quite dramatic. Now they do a monthly report, and I'm not going to go through the report, but the important thing is to take from the report is that construction disputes are real and are big. And the human factor, generally the lack of knowledge and understanding is one of the prime factors for disputes. And the important thing, early avoidance, is the key to prevent such problems. All right, just a sound check. Can you guys hear me properly? All right, if you can hear me, just say so, then I know. All right. Now, if you look, okay, that's great. Now, if you look in the law for an agreement to enforceable by contract, it needs to have 4 options. If you can run the next screen for us. All right. Now, this is one thing. All lawyers will agree with you. Any contract needs to be complete. It needs to be accurate. It needs to be final, and it needs to be executable. Any lawyer will agree with you. Next slide. Next slide, please. Now, the problem we have in no, one slide back. One slide back. Yes. Now, the problem we have in construction, our contracts are usually not complete, not accurate, not final, and often not executable. We often go into a contract with only a feasibility design. So it is ready, not ready yet. And that is a challenge for any lawyer to understand. And the general lawyers battle to understand construction. You do have your specialist construction lawyers. They understand it quite well. And this is really where dispute avoidance comes in. Next slide, please. Next slide.
Okay, let on.
All right. And this is where dispute avoidance comes in. Go back to next slide. And go back to the previous slide. Yes. Now, dispute avoidance and a dispute board doesn't need any legal or act like with an arbitration. It doesn't need that. And dispute avoidance is really the only proactive alternative dispute resolution. And that is why it makes sense. Next slide, please. So what is a dispute board? A dispute board is something which is absolutely, it needs people which are independent. They must not be connected to either the employer or the client or the contractor. They need to be knowledgeable both in both in the type of construction as well as in the contract. And then very important, they need to be available so that they can be contacted. But that availability can be through Skype, can be through Zoom, can be through different things, but it also needs them to come to site on quite a regular basis. All right, next slide, please. Now, a dispute board has got basically two roles. It's got an avoidance role to try and prevent, and this is really the big thing about it. And it's fairly new that they're developing more and more into the avoidance, but they also got, if you want to, they can have also an adjudication role, which is a little bit going more and more in the background, and the avoidance is coming more and more into the front. Next slide, please. All right, now if you look at that graph, you have got a possibility of either a standing board, dispute board, or an ad hoc dispute board. Now, for an ad hoc dispute board, where they only put the people together from the start of if there's a problem, they cannot prevent it. So currently, we are pushing more and more for standing boards, which can do a lot on the avoidance and I said there avoidance and adjudication, but actually avoidance and prevention. And secondly, the secondary role is then the adjudication. Next slide, please. If you do have a standing board and they come to the site once in 2 months, once in 3 months, they grow with a project. They understand the project. They know where are the things that can go wrong. They ask questions so that other people start to realize where are the potential pitfalls. And in that way, they help them to identify and raise red flags before it becomes a dispute. All right, so if you look at the process on the left is for an adjudication. That is, sorry, it's for a recommendation. If the both parties come to the dispute board member and they say, what do you think about this? He goes at it, he looks at it, he talks to him, and he gives them a recommendation. They don't need to follow that recommendation. But we have found that because it is given by an independent, knowledgeable person, we find that both the contractor and the engineer tends to listen with quite a lot of emphasis to recommendations. All right, next slide. If I look at, all right, sorry, one slide back. Just go back one slide. Yes, on the right-hand side, that is basically the process in FIDIC, where you ask for an adjudication. Now, adjudication, if both parties accept it, it becomes final. But if one of the parties does not accept it, it can still go to arbitration. But generally, if you do the recommendation, you find that people tend to accept that. And if someone grows with it, if the dispute board grows with the project, people tend to accept the rulings of the dispute board or the recommendations of the dispute board, and that prevents a lot of the potential major problems that go into disputes. All right, next slide, please. Now, if you look at dispute boards compared to any other alternative dispute resolution, if you look at all of those things, the higher on the pyramid, the less the cost, and the further you and the more control the parties has got. If you take it further down the pyramid, costs become more and control becomes less. Next. And in construction, we basically have those four options. We have right on the top is negotiation. People need to talk with one another, which is really the ideal. And this is where a standing dispute board comes in quite a lot because they help for people to talk. Then the next step down is for a, when you ask a dispute board for their opinion, which they then give. Further down, you can ask a dispute board for adjudication, but then you start getting specialists in and the cost for the parties become more. And then eventually, if you drop down, you go to the avoidance, which are costing a lot of money because of the legal representation. Next item. I just want to touch on Florida Department of Transport. They started putting in dispute boards in their projects in 1997. And it's quite interesting to look at their experiences in how they found this to be. During that 20-odd years that they've been running dispute boards, they floated more than $50 billion in projects. Their DB costs was less than 0.1% of the project, which is just an insurance, especially if you look at what it is. Overruns on cost dropped from about 12% to less than 4%. And project time overruns dropped from 30% overrun to around about 10% over that 20 years. And even the input from the clients on inspections dropped quite considerably. And all their contracts, they've now made a rule that all their contracts more than $15 million have to have a dispute board which need to go to that site once a month. And this is just how positive these people have found this to be. All right, let's look at the next slide. That gives you a graph of how things improved at Department of Transport in Florida from initial very high time overruns. It dropped down quite drastically, and from reasonable cost overruns. Remember, these are all contractors with good, proper road building contractors which were doing the work. And you will see it also dropped quite drastically. And this is one of the cases which show just how positive a dispute board can work. But important is that they need to do it from a very early stage in the project so that these guys can work with a contract and to prevent problems. They are guys that knows the industry. They are guys that knows the type of work, and they need to pick up on potential problems, asking the questions. Did you check that? Did you check that? What will happen if this? What happened if that? Those are the things that help. All right, next slide. What is also interesting is the DRBF, the Dispute Resolution Board Federation. They've done some surveys in the past few years. And if you look at that graph, you will see whenever they do dispute boards, they found very positive results. And if they do dispute boards where they concentrate on avoidance, so the standing dispute board, the guys that come in from an early stage, it is really phenomenal, the successes that they've had. And this is globally. This is not only in America or in Europe, this is globally. I mean, as if you look there at the 500 odd cases, only 3 of them actually less than 1%, 0.5% were referred to arbitration. And only 3 of the 500 cases were overturned in an arbitration case. So if you go and look further into it, you'll see that the process had a success rate of, well, about 95% in avoiding expensive follow-up dispute resolution procedures. All right, next slide. And that is really the crux of the matter. A little bit of prevention is worth a pound of cure, which Benjamin Franklin has said. And this is just what I quickly wanted to touch with you. Let's just go through, if you go through 1 or 2 more slides, you will see some of the comments we got from people in the industry. So just go next slide. And the next slide. And the next slide. Yeah. Now, this is European EIC, European Institute of Contractors. One of the contractors say the members were absolutely impressed by the professional approach of a DAAB and for the contract and effective part of the dispute resolution process, which has been prevented. Next slide. There's another contractor, and again, they just sing the praises of the dispute board. Even though it was a little bit late, the sole dispute board member has helped quite dramatically to prevent, to solve problems and to prevent things from going totally off track. All right, next slide. Another contractor, again, quite very happy with the dispute boards. Next slide. Yeah, even there, if you look at what this employer said, they were on their way to cause a lot of problems in their project, and the dispute board brought it back just because they started helping. So in summary, dispute boards do not need any legal requirements. You don't need any legal act, like an arbitration act, you don't need that. You don't need any sanction from the state. It is standard, and it can be either incorporated in existing contracts, or you can add it, you can either add it in a contract. As interesting as all your FIDI contracts already allow for a dispute board, but even if it is not in your contract, you can always add that. And as you could see, the responses you get, if you've got the right team running with you, the amount of money that you spend on a dispute board is absolutely a drop in the ocean compared to the advantage you get out of a dispute board. All right, with that, that is basically just what I wanted to share with you, and I am happy to answer any questions if you would, if you have.
Okay. Christian, I'm from a problem for today is some people can listen again your presentation. I may ask you the question later by Yellow or by email. But I'm listen clearly. I just want to mention difficulty from Vietnam. We are civil law country. We are not a common law. We are civil law country. And in Vietnam, arbitration is okay, legalized. Mediation right now is okay. We have the legal framework. But for adjudication, we don't have the legal framework now. And the Ministry of Finance always request people to delete the DAAB clause from the credit contract. Always make it go to the arbitration or adjudication. So I just wonder whether any civil law country the same problem and how they fix the issue. I mean the civil law country.
All right. For a start, you do not need any legal framework for dispute avoidance.
Yeah.
Now, what you can do, what you can do is, if you look at the American way, and this is more and more, you can do also, if you look at the ICC rules, they do what they call a dispute resolution board, which basically is doing exactly that. You just take the adjudication out. It's just like a advisor that sits there that picks problems up. So you can still do that without transgressing any law, without transgressing any guidance from the ministry, if you stick with avoidance, with recommendations. So you do no legal issue. And the American way, and this first one on the Department of Transport of Florida, they only do recommendations. They do not do any adjudication. And the whole American way is really only on recommendations. On the maximum is a recommendation. The larger part is just sit and work with a team, identify potential problems, and help them to identify these soon, to address them before they become an issue. So dispute boards, especially in the avoidance part, you can bring in Vietnam today, no problem. You are not transgressing any law. You don't need any structure in Vietnam to bring that in, and you also don't transgress any recommendation. You just take out the thing to say a dispute board as, you don't make a dispute adjudication board, you make a dispute avoidance board. And you take out the right of the DB to do adjudications, and you're clear. And this is really the advantage of a dispute board. The adjudication is just an add-on which initially came in from the British and the Europeans who wanted to make adjudication. Adjudication doesn't have to be part of it.
From the other people online, do you, Mr. Tuấn Anh, Miss Mai, do you have any question to Christian? Please, love also.
Okay, guys. The DB approach is very good because the legal fees in the West is a huge amount of money, and even in the case presented by Christian, thank you. when a DB board actually advise and the engaged party commit to settle,
Cho nên là em cũng phải
it's going to be part of binding items in the contract. The problem that Trong raised to all the guys here is that even in that process in Vietnam, when it's agreed, it's still not binding. The most important is that
yes, no, that is fine. It is not binding, and this is not what we don't need. It doesn't need to be binding.
And then it is the reason why, since here the legal fee is too low against the case per se, the whole value, and then the people may choose the different approach. Like they may want to settle by DB, and then they suddenly want to turn around, and if they do see that the party is going to lose some money, they try to make other party is going to be losing as well. So it takes a long time, and our court normally have to go on with 2-3 steps that cost you like 10 years at least to settle the case. And to be frank, I like to settle by the way that all the people are losing less than they can. But not in this country. It's good, but we need to learn.
Yeah. What we find, especially with the avoidance part, you know, that is really the only proactive alternative dispute resolution. Everything else, even the adjudication part, is retroactive, is post the problem. We find that if you can get the avoidance, the whole process on site becomes much more effective, much more conducive. People start talking better to it, and it helps the project as a whole, not the individuals. It helps the projects to come in time, much less cost overruns, much less time overruns, and we find that to be, for the project, a much more positive approach.
Được, chiêu này hay đấy. Được, nghe được này, bấm hết không? Được.
What I would suggest is for this association to go and investigate and maybe look at 1 or maybe 2 projects and run them as a test. So, all right, we bring in either a 1-man, you can have a dispute board either as a 1-man or as a 3-man, but bring in a 1-man dispute board and concentrate on avoidance. He goes with you, he comes and visits the site once a month, once in 2 months. He picks up on where he's seeing things going offline. And that is something you can consider.
Được nè. Trong bữa ra nó làm được luôn nè.
Okay.
Mr. Trong, any other questions or comments or suggestions?
I think that some of us cannot follow full of your presentation. So in this case, Christiaan, let's we raise the question through Gallo or by on linking to you or later. I think that's on for the second topic. Yeah, and
good.
Okay. Now is Mr. Thank you very much, Christiaan, for your presentation. And we will have, after people watching the record